Hello friends, in the series on the income tax cases, today we will discuss an issue in which a very important matter was before the Honorable Delhi High Court, and the matter was that whether the principle of consistency plays a vital role in the income tax proceedings, especially in the cases when there is no change in the facts of the case of the assessee. This issue has been taken up by the court in the case of Commissioner of Income Tax Exemptions versus Hamdard, Laboratories, India, and this case is reported in 480 ITR, page number 498, and the matter has been decided by Honorable Delhi High Court on 10th September 2025. The present case relates to the assessment year 16-17, and during the assessment year 16-17, the assessee has filed a nil return by claiming the exemption under section 11 and 12. The case of the assessee was under scrutiny, and during the assessment proceedings, the assessing officer observed that some properties of the assessee of the trust has been given on lease or rent to two trustees at a rent of rupees 45,000. The Wasudeo was of the opinion that the assessee has violated the provisions of section 13 subsection 2 clause B and section 13 subsection 3 clause B, which broadly says that if any undue benefit is given to the specified persons, in the present case those specified persons are trustees, so the assessee is not entitled to the benefit of exemption. So on this basis, and by relying on some data from the internet, the assessing officer made a conclusion that whatever the rent has been recovered for the services provided to the trustees is not as per the market, so he denied the exemption. When the matter was before the learned CIT appeal, the CIT appeal sought a remand report from the assessing officer, and then this copy of remand report was given to the assessee and the comments of the assessee were sought. The CIT appeal was of the opinion that the assessee has been given the benefit of section 11 and 12, and the same issue was there in the three preceding assessment years, that is assessment year 13-14 to 15-16. And since there was no change in facts, and in the preceding years also the same property has been given on rent to the trustees who were serving the society since last 40 years, and depending upon their seniority and on the basis of the services they render to the society since last 40 years, and according to the service rules, then the rent charged is adequate, and it cannot be said that some undue benefit has been given to the assessee in violation of section 13 subsection 2 clause B and section 13 subsection 3 clause B. So the CIT appeal allowed the appeal of the assessee. The CIT appeal was also of the view that the assessee is also entitled to exemption under section 1023C clause 4, and it is very clear that there is no undue benefit to the trustees. When this matter came before the tribunal, the revenue was contesting that the CIT appeal has also given the relief to the assessee on the basis of section 1023C clause 4. For this, the tribunal said that if the assessee comes with a submission or with a ground with the CIT appeal, then it is the duty of the CIT appeal to adjudicate that matter, and it is not the case that the CIT appeal should only remand the matter back to the AU. The CIT appeal has co-terminus power of the assessing officer. The tribunal also said that in the present case, the order of the CIT appeal by deleting the disallowance or by allowing the exemption under section 11 and 12 is justified, because in the present case the revenue is not made out a case that some undue benefit has been given to the trustees of the trust. The tribunal also said that in the present case the EU has not commented on any of the judgments which has been referred by the assessee of the Supreme Court and the jurisdictional high courts, which has settled the law over a decade, and there is no change in the facts of the case also. So the same view has been taken up by the Delhi High Court when the revenue took the appeal to the Delhi High Court. So from the present case, it can be safely concluded that the principle of consistency plays a very vital role in the assessment proceedings. Also, the principle of Res judicata do not apply to the income tax proceedings. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax Exemptions versus Hamdard, Laboratories, India. And this case is reported in 480 ITR at page number 498. And the date of the judgment is 10th September 2025. Thank you, friends.